and Anchor Health. And I apologize. For some reason, my video is not working. I didn't intend to appear in front of you as a disembodied voice. I've got my suit on, but I can't get my camera working. So good morning, Your Honor.
Good morning. I guess my apologies to you that my camera unfortunately is working and my ugly mug is still on the camera. So my apologies there. No worries. These things happen in this day and age. We are here for oral argument on the motion to dismiss. I've reviewed and considered the motion to dismiss filed March the 17th, the response filed April the 29th. The reply filed May the 21st. I'm only saying this just so that if there's an appellate record, they're like, why are we having oral arguments some 3 months after that? I will note that we had said it earlier and the date was not convenient, and today is a date that works for everyone. I've reviewed, have considered everything. Mr. Kovalt, this is your motion. Go ahead, please. Each side's going to be given 10 minutes worth of time to argue. Go ahead, please.
Thank you, Judge. I'm going to give you just a few observations. I think if you take a look at all of the cases cited by both sides and you were to put them on a spectrum, where on one end there's clearly personal jurisdiction and the court denies a motion like the one that I brought to you, and on the other end there's no personal jurisdiction. This case falls within the portion of the spectrum where courts have granted such motions. The key here that I'm going to emphasize in a minute is whether the defendant is the one directing the contacts towards the Forum of Arizona. It doesn't matter what the plaintiff does. The plaintiff can't induce communications, create communications, and create these minimum contacts. So here, what we are looking at is two different defendants. We've got Mr. Blakely, and then we have the Tennessee entity of Anchor Health, LLC. I'd like to give you two major cases that we advanced in the papers for Mr. Blakely. Our position is he's an agent who contracted for a fully disclosed principal, which means that he shouldn't have any personal contractual liability. We gave you the Ferrarell versus Robinson case and the Valley National Bank Sunnymead case. Both of them discuss that. They say that the court doesn't have to simply accept the words of the pleadings. The court can actually take a look at the nature of the contract and then conclude that based on that, the principal was being, the agent was signing for the principal, and therefore the agent cannot be held personally liable. We also gave you a statute in that regard. It's ARS 29-3304A, which says that members and managers are not ordinarily liable for the debts of the company. And so there has to be an additional showing, like some kind of piercing.
Let me ask you about that.
Yes, sir.
Because I guess, are you telling me that the entity is an Arizona LLC such that Arizona should have jurisdiction over its LLCs, or is this a Tennessee LLC? In which case Arizona's LLC law would not be applicable.
We're saying that it's a Tennessee LLC, and I take your point, Your Honor. I take your point about the Arizona law governing the way that Arizona LLCs work. I guess the last point that I would make on this point is in the Black versus Perkins case, which says that parties are bound to their pleadings. And our main argument here with Blakely is paragraph 10 of the complaint says that he was signing on behalf of the principal, Anchor Health. And so we're asking you to stay within the four corners of the complaint and hear the plaintiff for what they're saying. So we don't see another.
Doesn't the complaint say Mr. Blakely executed an agreement on behalf of defendant who is unnamed? That's the exact phrase. It's sloppy. I'll give you that it's sloppy.
Yes, sir. That's what it says. And
okay, it doesn't say Anchor Health. Can you conclude that they're saying Anchor Health? Maybe. Mr. Cobalt, as far as Mr. Blakely goes, I am tending to agree with you considerably, but my question to you is this: don't I need a fact or two such that a motion for summary judgment in 60 days is probably the right way to go about this? I think you're right. And I just think we probably need a summary judgment. Why am I guess my question is, I feel like I'm somewhat mistaken on that. And that's where I am. I'm inclined to agree with you. I just think this might be a whisker premature.
Okay, I hear you, Your Honor. I guess I'd like to see what Ms. Malum says about the other facts in the complaint, the other allegations that support the idea that Mr. Blakely was personally signing on his own behalf, notwithstanding the language of the contract, and the allegation of complaint paragraph number 10.
Yeah,
And
I'm going to
then-
ask her about a motion for judgment. Preview. I'm going to be asking her about a motion for judgment on the pleadings if Mr. Blakely was to deny that he executed this on behalf of his own, that the defendant referred to in paragraph 10 is not him, but it's Anchor Health. Why a motion for judgment on the pleadings would not be warranted, or a summary judgment motion. But we'll get there. Go ahead, Mr. Cobalt. I'm sorry.
Thank you, Judge. Thank you. No problem at all. And I think this is a good conversation. I'm going to shift to personal jurisdiction for Anchor Health and Blakely. And so here, again, my theme and my frame that I told you at the very beginning was that I think this falls within the portion of the spectrum where courts have granted it. I'd like to just pluck two cases out and discuss them with you, and then we can chat about anything the court's interested in. I'm going to talk about Myers versus Hamilton Corp., which I think is one of Ms. Malum's primary arguments. And then I'd also like to talk about North Cross versus Jocelyn Fruit. And so both of these cases are personal jurisdiction cases. They're both a little bit older. North Cross is 1977 and Myers is 84. But in all the subsequent personal jurisdiction jurisprudence, I don't think that the main holdings of those cases have been affected. So here's what happens. We've got out-of-state contracts. And so in Myers, it's the Carnival Cruise case. So Carnival's advertising in Arizona, it's sending advertising to Arizona. It's got an agent in Arizona that it contracts through. The contract was executed in Arizona. The Arizona Supreme Court says we have no problem with this. This is personal jurisdiction. Now, in Myers, it cites approvingly to North Cross. So then if we take a look at North Cross, this is District of Arizona. We've got an Arizona produce seller. We've got a Colorado purchaser. Colorado defendant initiates 5 purchases. So Colorado is initiating contact with the Forum of Arizona. Orders are placed through a Colorado agent, contracts are consummated in Colorado, goods are shipped FOB Colorado Springs, and defendants have no offices or employees in Arizona. And there, the holding was no jurisdiction. So our argument, Your Honor, is on the facts as pled by Ms. Malum and on all the papers. Our situation with a Tennessee individual and a Tennessee entity falls squarely within North Cross. It's exactly the same thing. So Arizona reaches out to Tennessee, says, do you want to make a deal? Arizona is sending Tennessee invoices. Arizona is sending Tennessee these allographs. There's no pled allegation in the complaint as to where the contract was executed. I think it's in Tennessee, but that's outside the 4 corners. I'll let Ms. Malum address that point. And so I think those two cases give you a really good read on where it is that Arizona feels that the jurisdictional question lies. It's not just the number of contacts, it's the quality. And it really matters who's calling who and who is responding to who. And there is case law that says it doesn't matter what plaintiff does in Arizona to try to induce contacts and defendant is responding and defendant is paying. It really matters what the defendant is doing to reach into Arizona, because then it's completely fair for that defendant to expect that Arizona courts are going to assert jurisdiction. So this is the very end of my prepared remarks, Your Honor. I'll save a minute or two on reply, and of course I'll answer any questions. Here's what we suggest the disposition should be. We don't think that the account stated or unjust enrichment claims change anything. It's all the same stuff. It's whether or not money is owed by a Tennessee defendant to an Arizona plaintiff. Here's what we would propose. It could be that Applied Biologics can figure out more facts to plead to get around some of these issues that we've raised. Assuming the court is entertaining this motion right now, what we would ask is that the plaintiff be directed to file a motion for leave to amend if it thinks it can. And then that way, the defendant, who's already been the out-of-state defendant, who's already been burdened with responding, will have less of a burden the next time around. And we ask for that because what the plaintiff did in its response is it didn't say these are all the facts that we would allege if you gave it to us, Your Honor. They just say we could do more, which they may be able to or they may not be able to. So for all of the reasons that we just mentioned, we're asking you to dismiss, Your Honor. We're asking you to award fees because this issue arises out of a contract. We're asking that if Applied Biologics wants to take another swing at move for leave to amend to do so. And we very much appreciate your time. Thank you.
Thank you. Go ahead, Ms. Malum. I'll go ahead and hear from you.
Thank you, Your Honor, and thank you, Jason, as well, for your remarks. So I want to start with just talking big picture about the relationship between the parties as pled in the complaint and as in the exhibits attached to the complaint, which you can consider. The agreement is a signed contract between Mr. Blakely, the defined customer, and the agreement. And then it's for a very specialized product. This is skin tissue, human cells and skin tissue. Defendants ordered product from Applied Biologics 158 times. This isn't a one-off transaction. This isn't like North Cross where there was only 5 orders. 158 orders into this jurisdiction is a substantial amount of orders. The total amount of product that he ordered, or perhaps Anchor Health and Wellness ordered, was $8.3 million. He then made partial payment into this jurisdiction of $1.6 million, leaving an outstanding balance.
How was that paid?
Your Honor, I couldn't tell you if that was check or wire. I'm not sure. But I do know he satisfied a partial amount of the outstanding balance.
Okay.
So I'll start, I guess, with North Cross, which is the case that Mr. Koval emphasized. And in that case,
well, let me just ask you something else since you're on the thing.
Go for it.
On the contract, on the first page of the contract, which is an exhibit to the complaint, there is something that says distributor is RX Wound. Who is RX Wound? Who is Andrew Stokes?
I'm not sure who Andrew Stokes is, Your Honor, but RX Wound would be a third-party distributor that we may have used to initially solicit the defendants, but that's not in the record. And I don't have facts necessarily supporting the relationship in this case between RX Wound and defendants and plaintiff.
Okay, go ahead, please.
So in North Cross versus Jocelyn Fruit Co., there were 5 orders. They were made via telephone. There's no written contract between the parties. Very different situation. Here we have a written contract. One of the cases that we cited in our response is the planning group of Scottsdale case. And in that case, there is an actual contract between the parties. And the court is satisfied with jurisdiction because defendants knew that the plaintiff was located in another state, took out a loan from the plaintiff with interest to be repaid in this state. So that's a very similar situation here. We don't have an affidavit by the defendant saying that they did not know that they were dealing with an Arizona entity. We don't really have any controverting statement from them to that effect. The only thing that we can take from their response is that, sure, they did know that they were dealing with an Arizona entity. They placed 158 orders from that Arizona entity, and they've failed to satisfy the outstanding balance. Even if, for example, they didn't know that this was an Arizona entity that they were entering into a contract with, that they had to perform in Arizona, they definitively knew after placing the first order, because every single order that we send them has in bold in the top left corner, fulfilled by and payable to Applied Biologics LLC with our Scottsdale, Arizona address. So there is performance due in Arizona, and they did avail themselves of the forum by continuously placing orders from an Arizona entity. Again, this isn't like a situation where you're on Amazon, you're scrolling through products.
But that's not in the complaint, is it?
It is. The invoices are all attached to the complaint.
Okay, I see the contract. Okay, very good. Oh, you're right. 183 pages of invoices. I got it. Go ahead.
And every single one, Your Honor, says fulfilled by and payable to Applied Biologics LLC, Scottsdale, Arizona. So they did, in fact, have notice at some point, presumably after that very first order, that they were dealing with a Scottsdale, Arizona entity and decided to continue to avail themselves of the forum.
Let me ask you, you say $1.65 million was paid. I believe that is paragraph 15 of the complaint. Were those the first 20, 21, 22, 23? Were they current on the first invoices? Which ones were paid?
I don't have the answer for that, Your Honor. I'd have to get some AR and discovery from my client to produce to show how that the outstanding amount was, the payments were applied to the outstanding balance. I don't think necessarily that makes a difference, though, for jurisdiction, because the question here is the contacts that defendants made, and by continuing to order product, they continue to avail themselves.
I struggle with that conclusion, Ms. Malum. I think you win this motion if it turns out that invoices 1 through 20 are paid in full, because if you look at the sequence of it, invoices 1 through 20 needed to be paid, and that's $1.4 million. That needed to be paid before the invoice date on, at least looking at your motion here, before the invoice date of invoice number 21. So if they are current, they've paid $1.6 million to Arizona before invoice 21 is issued on May the 20th. But I mean, aside from that, I don't know. I mean, if the 1.6 was paid at the end of the road in February of 2025, I don't know that you can assume that they are sending payment to Arizona at the time when they're making other orders.
I understand what you're saying, and unfortunately, I would love to tell you that it was applied to 1 through 20, but I don't want to mislead the court. I'm not sure when the payments were made, and so that's something that I would have to check our AR summary to discern that. I guess what I will say to that end, though, is, you know, they still ordered 158 times, knowing that they were ordering from an Arizona entity, noting that they were bound to pay and perform in Arizona. And
wait a second, wait a minute, time out. They're not an Arizona entity, they're a South Dakota entity, correct?
I think they might be a Tennessee entity. They're a Tennessee entity, but they did, their performance was due to an Arizona entity.
Okay, well, paragraph 1 of the complaint says plaintiff is a foreign manager managed limited LLC organized and existing under the laws of South Dakota with its principal place of business located in Arizona, in Scottsdale.
Apologies, Your Honor. Yeah,
no.
It is. You're correct on that. Yeah. Performance was due in Arizona, but not an Arizona entity. That's correct.
Okay.
As far as Mr. Blakely and the contentions about paragraph 10, who entered into this agreement, the defined customer name is John Blakely. There's no affidavit from Mr. Blakely as regards to, you know, was he entering into this contract in his individual capacity as a representative for the entity. All, you know, affirmed to the court that Applied Biologics has a lot of litigation going on in the state right now, seeking outstanding AR. In many of those cases, the providers work, perhaps they're associated with a hospital. They might also have an independent practice. They order the product in different capacities. So here, I can't say at this time whether Ms. Blakely was ordering the product for use for Anchor Health and Wellness, whether he had his own practice going as well. I think we need some discovery on that. And then after discovery, the parties convene and confer about, you know, whether Mr. Blakely remains a proper named party in this case. I just can't attest to you at this time without knowing how the product was used, whether or not that's the case. And then the final thing I'll say to that end is just that, you know, we do have many cases in Arizona from Applied Biologics with defendants seeking AR. Judge Gordon recently found that 4 sales and 3 invoices were enough to find jurisdiction in Arizona. Judge Julian found that 9 orders were not enough, but in that case, defendant had submitted an affidavit with contrary facts saying that they had never interacted with Applied Biologics, that all of their interactions had been through a third party, that third party had solicited them, and that's who they made the orders through. And so there's just no controverting facts here from defendant that would push that over the edge to make this turn out like the case where jurisdiction was not enough in Arizona.
No. And were sales taxes paid on any of the purchases, to your knowledge?
That's a great question, and I don't know the answer to that.
Okay. All righty. Anything else, Ms. Mount?
Nothing from me.
All righty.
Thank you.
Mr. Cobalt, can you help me? Were there any taxes paid on any of these things?
I do not know, Your Honor. I am limited to what's in the complaint. I really haven't gotten a lot more from that from my Tennessee defendants. One thing I would say is we did not submit an affidavit. I don't know the circumstances of the case in front of Judge Julian. I'd have to take a look at that case law. It seems a little odd that the defending party, I suppose there's case law that says for a personal jurisdiction issue, the defendant can submit an affidavit. It seems to improperly go outside the four corners, but I'm not going to stake out a hard position that that's not okay. But that's why we didn't do it. The only last point that I would make, Your Honor, is on this disclosed agent working for a disclosed principal issue. If you take a look at those cases that we cited, in both of them, the plaintiff asserted that the signature in various places on the contract was sufficient for the agent to be a defendant. And in those cases, the courts sat down and took a look at it. Like, for example, one of them was a check. The check had an entity name at the top, but then an individual signed for the entity at the bottom without any kind of indication that the person was doing that in a representative capacity. And the court nonetheless concluded that the agent was signing on behalf of the principal alone. Other than that, Your Honor, I've got no further argument unless you have other questions or clarifications for me.
I don't. I will take this under advisement. I will tell you that this is kind of where I am. As you can probably tell, I've spent a lot of time looking at this. I know what's going on. I'm torn. Where I am is, look, we don't know where the contract was signed. We don't know how the contract was initiated. We have no idea how the orders were placed, whether it was third party or direct. I'm assuming these were direct. We have no idea what invoices were paid. We have no allegations of how they were paid, whether it was wired or not. And I mean, quite frankly, if it turns out that the application of the invoices, if the first ones were paid and then if the first ones were paid in a way that they were paid to Arizona, like by check or things like that, which necessarily would have been sent to Arizona, and if there were subsequent purchases after that, 100, 140, 150 or whatever, 130, 120, whatever they are, after that date, I'm probably leaning much more toward where Judge Gordon came down. If it sounds like there is an intermediary placing the order that's outside of Arizona, then I would probably be leaning more toward where Judge Julian came down. So I don't know. More likely than not, I'm going to probably grant leave to amend. And to get answers to a bunch of these questions, just because I think that these questions will guide us one way. I think it's a pretty close call, and I think answers to these questions will nudge the determination to one side or the other, and make it much clearer. The last thing I think either of your clients probably wants is to go do an appellate battle and realize that there is or there is not jurisdiction and to get to try it twice. So I really tried to put the effort into this, even more than normal, to try and get it right for your clients. Last thing I may suggest, if you wouldn't mind, what you may consider doing is perhaps you can figure out a way to confirm whether or not Mr. Blakely is going to be saying, no, this is all, that he'll stipulate that it is Anchor Health or not. or as to whether he's bound. Maybe you can reach that conclusion, maybe you can't, but maybe we need an answer as to that. I'll take it under advisement. You'll have a ruling probably by the end of the week. And thank you for the excellent briefing. You took me back to first year of law school when we were ducking pterodactyls back in the age when you get as old as I am, unfortunately. And we'll stand in recess. Have a good day, folks.
Thank
You
you,
too.
Judge.
Thank you.
Bye now.